Good afternoon, everybody. This is Jill Chilcote, partner at Lincoln, Gustafson & Serkos, and welcome to our webinar on effective use of trial objections. Please make sure that you're logged on for the entire time of the webinar in order to get full MCLE credit for this webinar. Today we have Tom Lincoln from Lincoln, Gustafson & Serkos presenting our topic today. Lincoln, Gustafson & Serkos is a San Diego-based law firm with offices in Nevada, Arizona, and Nevada, Arizona, and California. And now I will turn over the webinar to Tom Lincoln, and we'll get started.
Thanks, Jill, and thanks to everyone who is listening, giving up your lunch for this interesting topic. We're going to talk about trial objections, and the key ideas I want to get across up front, and then as we go through it, I'll address it more, is that trial objections are very difficult. They have to be made within a split second. They can be counterproductive, they can be disruptive, they can draw attention to things that you don't want to draw attention to. And on the other hand, you have to make certain objections in order to preserve the record or to accomplish other tasks. So that's the key that I want to get across to everyone. And we're going to go through it. I'm going to talk about evidence and facts and how it gets kind of channeled into ultimately what's admissible at trial. And my screen has frozen up. You know that you're going to get MCLE credit for this, and as Jill said, you have to stay logged on to get that. So in any case, there's a universe of evidence. The universe of evidence is everything that potentially could weigh on an issue. And ultimately, that universe of evidence is going to be focused in and reduced to admissible evidence and ultimately admitted evidence. The filter through which all of that occurs are the objections that we make. So I'm going to kind of go back and start from the beginning. The universe of evidence really arises from some type of event, whether it's the construction of a project, condominiums or single-family homes. Maybe it's a slip and fall. Maybe it's a breach of contract. Some event has given rise to responsibilities and obligations of the party. And that event is surrounded by lots of facts, the universe of evidence, and after the event occurs, the event is defined in the pleadings of a case, and is flushed out by discovery and then pretrial and trial. The pleadings of the case define the issues and establish the relevancy of what is and what isn't relevant. As you know, the pleadings are the complaint, and that sets forth what the plaintiff's claims are and references the event, and that defines, from the plaintiff's standpoint, the potential universe of evidence. And then the other side answers that, and that can further define it by affirmative defenses. And then there are cross complaints, or if you're in federal court, or Nevada, for example, or those that follow federal jurisdiction, third-party complaints. That's what defines the issues in a case and what makes evidence either potentially relevant or not. After the pleadings come the discovery phase, and I know everyone knows this, but I want to zip through it because that's where all this evidence and information comes from that is ultimately potentially admitted in trial. So during the discovery phase, there's more information that now is exchanged and must relate somehow to the issues framed by the pleadings. And where do you get that? Well, you get it, first of all, hopefully immediately meeting with your client, and that your client can identify witnesses and documents that are necessary or related to the case. You can talk to experts, and experts can provide you with more information, filling up that universe of evidence. Ultimately, you take depositions, and the depositions provide information and facts. You do document requests, more universe of evidence is coming in, investigations, with the goal being obtaining all the witnesses in the case, all the documents in the case, using, liability and damage experts as the case may be, and ultimately demonstrative evidence. During the discovery phase, where we're collecting and identifying that universe of evidence, I always like to say on every case, in every legal manner, to keep an up-to-date witness and exhibit list, because what happens is, as we go through a case and witnesses and exhibits, documents are being identified, it's easy to lose track of that type of evidence. And so if you don't kind of keep track of it with an eye toward how am I going to get this into evidence as you get close to trial, you may find yourself unable to do that. So I like to keep a list of witnesses, and each witness would have a name, a brief summary of their testimony, and why it's important, contact information, and then maybe even a list of exhibits that might relate to that particular witness. Same thing with documents. I like to keep an exhibit list as we go along of all the exhibits, all the documents or other types of evidence, tangible evidence that will be used. And that would identify the document or the particular tangible evidence, a witness that is going to allow that document to be admitted. In other words, lay the foundation, establish its relevancy, something like that. Sometimes we think of documents, but we also have to think of which witness is going to be paired up with that particular document. And then think about any particular problems you're going to have. What objections, now we're starting to talk about objections, that could be levied against a particular document or witness. So we've got that universe of evidence, and we're trying to get it down into admissible evidence. We've discovered it. We've defined it by the pleadings. We've flushed it out through discovery, and we're getting closer now to getting it to be admissible. Objections are that, like I said, are that filter through which all of that universe of evidence has to pass in order for it to be admissible. And the concept is to reduce that universe of evidence to admissible evidence, which has to be relevant and unobjectionable. So evidence that has to be, that it would be admitted to a trial has to be obviously relevant and unobjectionable. It's relevant if it tends to prove or disprove a material fact in the case, tends to prove or disprove a material fact in the case. And the concept with the objections then is to keep the evidence out of the record or out of the jury, either out of the hard record of the case, the transcript of that, or so a jury can't hear what that evidence is. Objections also are used to speed the case along and not have it get bogged down. And it's also used to keep privileged information out of the case. So we make the objections pre-trial. What are the pre-trial objections? As we're going through discovery, depositions and document requests, there are various objections you can make to that. It's much broader in the discovery context. The standard is that it has to reasonably relate to admissible evidence in the case, or it has to somehow be a defect in the form of the question. It's a little bit different in trial. One of the ways that you reduce evidence before trial is motions in limine. Motions in limine are a very, very effective tool to limit evidence pre-trial, And it's so effective because when you're in a trial and you hear something or you see something that you need to object to, you have a split second to make a decision as to whether you should do that. The judge, who rules on the evidence, likewise has typically a very short time to rule on the objections. Motions in limine, however, are pre-trial, and you get to brief it, you get to argue it, and the judge then rules on it with a full briefing oftentimes. What I see is over the years is that there seems to be not a lot of thought going into motions in limine. What I like to do is, as I'm preparing a case from the very beginning up through trial, I like to keep a list of things as the case goes on, even at the pleading stage or discovery phase, a list of things that I want to bring motions in limine on so I don't forget them. So I have a whole separate list as I go on as to what motions in limine I want to bring. Motions in limine are designed to exclude evidence. That's what motions in limine are. I think people tend to broaden the concept of them, but they are specifically to exclude a specific piece of evidence. As you go on in a case, you're going to depositions and you're sending out discovery and reviewing all that, you'll see what the other side wants to introduce into evidence. And if it occurs to you that that should be a subject of a motion in limine, that's the time to do it. That's one way of limiting that universe of evidence, and it really is the most effective way. You can really whittle down all of the evidence and change a case drastically by motions in limine. I've written here, give to witnesses. I think it's important that every witness you call is aware of the judge's rulings on motions in limine. In other words, if you have a witness on the stand, either through direct exam or cross-examination, and somehow some question you ask elicits a response that is violative of the court's order on a motion in limine, first question the court's going to ask you is, did you tell the witness my ruling on that? So think of the scenario that a witness is on the witness stand, you're asking that witness a series of questions, the witness either responsive or non-responsive blurts out something the judge has excluded. So you don't want that to happen. My advice is, once the motions in limine are heard and ruled upon, you in written form advise clients and witnesses of the limitations that have been imposed. So you can demonstrate that you've done that. It's not just to cover yourself, but it's also to make sure that you're not running afoul of any of the court's orders. PowerPoint, everybody uses PowerPoints like me right now, but everybody uses them for opening now and closing and even presentations. And you want to make sure that you, as opposing counsel, see all PowerPoint presentations before they're shown to a jury and have them to have the ability to object and limit them. A motion in limine can say that before any evidence is presented to the jury or to the court, that it has to be exchanged between counsel and objections noted and ruled upon, something like that. Same would go for any document or demonstrative evidence. That's kind of a standard motion in limine that I think should be considered. And finally, voir dire. You can object during voir dire. And as you know, voir dire is your opportunity to talk to the jury and find out if they can be fair and impartial in this particular case. And I'm sure some of you have sat through voir dire, and the other attorney has stood up and is making an opening statement or is asking the jury for promises that they'll find for the plaintiff or against the defendant, or vice versa, etc. And you can't let you can't let a whole case be tried during voir dire because many people believe, and I am one of them, that first impressions are very lasting impressions. So it's important that you know what objections there are and that you make them during voir dire. And I'll just quickly go through some of them. Argument, that the attorney is arguing the case. They're asking the jury to prejudge evidence. They're trying to indoctrinate jurors on particular matters. They're introducing prejudicial matters that were otherwise excluded, or they're commenting on personal lives of attorneys and parties. And I want to talk about this last one, about personal lives of parties. I'm sure a lot of us have been in cases where the attorney will say, last night when I was at church and meeting with, the priest, we were talking about such and such, or things of that nature. That's always improper in a trial. For an attorney to personalize, this is the most important case I've ever had, or this is the clearest case of negligence I've ever seen. Or defense counsel is always defending people who owe a lot of money, or something like that. I'm being a little facetious, but the concept that attorneys are not supposed to personalize is based upon case law and other matters, and it's objectionable, and you don't allow it, and you have to object to it. So now we've talked about motions in limine, and we've talked about voir dire. Now we're going to talk about trial objections. And when you make objections in trial, we're going to step back for a second. Really what you're doing is disrupting the flow of what's happening in the courtroom. Whenever you object, all the attention is going to be drawn to you and then immediately to the court. I have actually sat on a couple of juries. They're both criminal cases, but I was a juror on a couple of them. And even though I had been practicing for many years prior to the first time I sat in a jury, and even more the second time, I can tell you, and I'm a lawyer and pretty familiar with this stuff, I can tell you that it's very hard to keep track of all the information that's being provided in a courtroom. And so what happens is you're trying your best to keep up with the testimony and what the attorneys are doing. All of a sudden somebody objects, and at that moment your attention is drawn to that person and away from what you were trying to follow. And it's disconcerting and very difficult to kind of stay on top of. So when you make an objection, the proper way to make an objection is, in my opinion, is to stand up and say, objection, the question is argumentative. Or objection, the question has been asked and answered. You stand up each time until the court says you don't have to stand up. Whenever, at least for me, whenever I'm in court, I always stand up when addressing the court, and until the judge says, Mr. Lincoln, you don't have to do that anymore, I do that. The types of objections I've just made, objection, the question's argumentative, is a legal objection. A legal objection is different than a speaking objection. A speaking objection is when you're not stating just the legal basis for the objection, but you're talking and giving either an argument or an explanation, and that's inappropriate. So I want to make sure that everybody understands that this is just my opinion. I like formal objections. I like to stand. I like them crisp and short. Then what happens after the objection is made, the court will either immediately rule on it, it's either granted or not, or the judge will ask for more information about it, and that's when you can provide your explanation. So substantive objections are different than form objections. Substantive objections are things like I have in front of you now. The MIL, the motions in limine, can deal with a lot of substantive objections pre-trial, and typically these are not all the objections, but these are some. Hearsay, basically hearsay is a statement made out of court that's testified to by either the same person or someone else in court, and for the truth of what's contained in that statement. And the concept behind that is that, hey, you want the witness here in court. You don't want someone outside of court being able to come and influence the proceedings without the ability to cross-examine that. Privileged information is typically, it could be husband and wife, communications between husband and wife. It can be attorney-client. It can be clergy penitent. It can be medical information. There's lots of privileged communications that are inadmissible. 352 is a California Code section that basically says that the prejudicial value of the offered evidence outweighs any probative value. And I think that's really the standard for any relevant evidence, meaning that every piece of evidence has to be weighed. How important is it to prove or disprove a point versus is it prejudicial, how much time does it take, etc. Another one is expert opinion. The particular witness is asked to give an opinion that only experts can give or that he or she has not yet been qualified to provide. A question can be objectionable because it invades the province of the jury. If you're asking an expert, well, wasn't it negligent for this person to do it that way? Objection invades province of a jury. Objection, legal conclusion could be another type. And mental capacity, everybody who takes the stand has to be of a certain age and have mental capacity to provide reliable testimony. So those are kind of substantive objections. And then we have a whole list of form objections. And one is asked and answered. You can't ask the same question twice, and that happens a lot. Objection, asked and answered. Calls for speculation. It's argumentative. The question lacks foundation. They haven't laid the proper foundation for it. Best evidence assumes facts. Vague and ambiguous. Beyond the scope. Beyond the scope is important. Every time the trial goes from one phase to another, theoretically, the scope of what's allowed is defined by the prior aspect of the case. So what that means is that on direct exam, you have the standard that all evidence that's relevant and unobjectionable can be admitted. And then on cross-exam, you can only ask questions within the scope of direct. And then on redirect, you can only ask questions within the scope of cross, etc. So it's kind of a funneling. The prior phase defines what's next up. And you would just say objection beyond the scope. So if you don't want certain things to go on during cross-examination, you need to be careful not to what they call open door on. Non-responsive is just that the witness is testifying to something beyond the scope of what your question was, and then, of course, leading. All of those objections, really motions in limine, voir dire, and substantive and form objections, you really have to have a strategy behind them, because as I said, remember what happens is the trial is flowing along, and all of a sudden you're drawing attention to yourself and to whatever's happening at that moment. So what I like to do is, first of all, I like to prepare the jury for the fact that there will be objections. So during voir dire, I often ask something like, ladies and gentlemen, there may be times during this case where I will object after a question's asked and state the reason for my objection and have a court rule on it. The judge will instruct you that that's the right of attorneys and obligations of attorney. Will you hold it against me or my client if I do that? And I do it a little bit differently than that, but that's the concept. The reason you do that is so that juries understand what you're doing, that you've already talked to them a bit about it, so they're not surprised. Why does he keep objecting? What's wrong with him or it? And that kind of thing. I think that's important to do so that they get an idea of that. I think you have to be prepared with respect to the objections. And being prepared means have a list of objections with you at trial. I was in a trial recently in which attorneys, they could sense that the questions were objectionable, but weren't either prepared or able to verbalize a specific objection to it. And remember, it happens in a split second. The question is asked. You're sitting there taking notes, thinking about where the testimony is going, what you need to be doing, and you have to decide in a split second whether or not to stand up and state a legal objection. And so you don't have much time to do that. And it's very hard if you're sitting there and you're trying to remember which potential objections you could raise. So I think it's not a bad idea, and I've been in many trials where counsel has a list of objections, and I keep a list of objections, particularly those that I think may actually occur during a particular phase of trial. I may even have some cases that relate to the objection, depending on, maybe it's the admissibility of a document and that's a business record, and I want to object because I know they can't fulfill one of the elements of the foundation of that business record. I may have, and I know objection lack of foundation, I know that, but I may want to have a case available to me that I can show the judge and opposing counsel for that, to bring that point home. So it's very important that you're prepared by knowing what the objection is and having support for it. And you can really do that because you can, when preparing a case for trial, you know, we all sit there and we think, okay, if I'm on the defense side, I think, who are the plaintiff's witnesses? Well, I know who they're going to call because I've got a witness list and I've got a section with plaintiffs, and I know which each witness is going to say pretty much. Either I've deposed them, or I've taken a statement by investigation, or I can, or through interrogatory responses, or I can just assume. I know kind of what they're going to say, and I can anticipate potential issues with testimony or documents and prepare objections for them. So I sit and I kind of visualize how the case is going to go. I do it with my own case. I'm going through my witnesses or my exhibit list, and I'm thinking, what's the other side going to do to object to this evidence coming in? And that's why I think it's so important to prepare witness lists and exhibit lists from day one. And you just add to them as you go along. You describe what the significance is of each. You think about and note how you're going to admit each. Maybe you're going to put in some objections in that chart or cases that will allow you to argue when those issues come up. The next strategy point is know what you are trying to accomplish. And by that I mean, unless you're trying to and believe you can actually get evidence excluded, oftentimes it's not worth making objections. You make objections to preserve a record on appeal. If you don't make a timely objection, oftentimes, depending on what the issue is, the appellate court won't accept the objection post-trial. So you are, one of the reasons you make the objection is to preserve that record on appeal. Sometimes if you're in court and you make an objection and the judge rules on it, you'll want to make a record of your objection, and if you're in front of a jury, you can't really do it at that moment. So the judge will say, well, let's wait till a recess till you make your record, so you can make your record. You can also do that during a trial at sidebar. Sometimes the judge will allow you and the other counsel to come up at sidebar and hear an argument and rule on objection or go out in the hall or something like that. And then you have the option to have it reported by the court reporter or not. I just want to say that make sure you do make a record, because on appeal, if the record is not made, it may be deemed waived. And you'll get pressure not to make a record by courts often because they want to keep the case moving and they think they've already understood it, but you have to get something down. And so at least at a break, you can make that kind of record. But you got to know what you're trying to do. I've seen situations where the attorney asks the witness a question and the other attorney jumps up, objection, it's vague. And so the judge sustains it, meaning that the judge accepts that objection. So then the other attorney tries to clean up the question, make it a little clearer. Objection, it's still vague. And they try to clean it up again. Well, now what's happening? Everybody is now so focused on that question and answer that if it happens to turn out bad for the attorney making the objections, what has he or she done? Instead of just letting a vague question go and a response that everybody really has no idea the significance of because it's in the stream of information flowing through this courtroom hour after hour and people are getting tired and they're not... This attorney has now drawn all the attention to this witness, this question, and is allowing the attorney to go over and over until they get the question right. So you have to understand that if you make an objection, it can shoot you in the foot by drawing attention to it, by having the attorney clarify. And I see this all the time. It's one thing to recognize a question for which there is appropriate legal objection, but there's quite another thing to decide in that split second when you're sitting there, gee, do I need to do this to preserve the record? If I do it, it's going to draw attention to it. Am I better off just letting it slide? And that's one of the hardest things that you have to determine. You know, I think when in doubt, my rule of thumb is this: when in doubt, unless it's clear that I have to do it to preserve a record, when in doubt, don't object. Sit there and let it come in. Particularly if it's to the form of the question that they can fix. And I think that's good advice, and it does the things that we've talked about. The other thing, finally, is being sensitive to the judge or jury. By that I mean that nobody really likes someone who's being contrary all the time, and I think that's how attorneys are viewed who constantly object. Now, there are situations when you will need to constantly object, and I think that you got to be very, very careful about that, because you don't want to be the person in the courtroom that nobody likes for obvious reasons. I think you can mitigate that some by doing what I talked about, and that is during voir dire, talk about the fact that you'll be needing to object. And in motions in limine, you can, start the process of objecting, so at least the judge knows where you're coming from. But you really want to not come across as someone who's trying to hide evidence or keep it away from the jury. So the only thing I can say about that is, the main thing is to gain the trust of the jury, that they trust you, that you're telling the truth, and that you're knowledgeable about the case, and that you're a likable person. People tend to be more receptive to people who they trust and like. And I'm not saying try to be phony so they like you, but try not to do anything that will make them dislike you. So from the very beginning, it's important that you don't come across as obstreperous, that just trying to shake things up. And as you go through the voir dire process and opening statement, you're gaining trust and credibility and a little bit of familiarity, so that when you start objecting, they have some backdrop to compare. So, those are my comments on objections. We've talked about the main thing is that you have to be prepared, you have to know objections, and you have to use them selectively during a trial, and if necessary to preserve a record, but when in doubt, probably better off not to object. That universe of information, starting with the event and going through the pleadings and discovery and pretrial and then pretrial, is all the potential information that can be whittled down and actually admitted into a trial. And it's defined by the pleadings and flushed out during discovery. That I like to keep exhibit lists and witness lists, so that you can think about and visualize what evidence you're going to be presenting and how you're going to be presenting it, what evidence everybody else is going to be presenting and how they're going to present it, and what objections. And then you start with voir dire and you talk to the jury about objecting. You object if there's inappropriate voir dire, and you go through opening statement with the same thing in mind and the rest of the case. It's important on motions in limine that you tell prospective witnesses how the judge has ruled, because if they violate the court's order on a motion in limine, you may be subject to sanctions, or your witnesses. And with that, I would ask that if there are any questions, we can open it up to that.
In order to do that, you can type into your question bar any questions, and we can see them on the administrator bar.
Well, not getting a lot of questions, either because I've answered everything or I'm not drawing enough attention to the whole thing. But so I'll wrap it up, unless we get questions, by saying that our firm does a lot of litigation and a lot of other type of business-related legal work, and I always say that. And I know some clients don't like to hear this because they think it just increases the cost. But from the very beginning of every case, I'm trying to think about what is that going to look like in trial. Who are the witnesses? What documents are going to be used? I'm trying to get in my mind how am I going to present the case, and what objections am I going to be up against. And I believe that the information I gave you about a witness list and exhibit list, even though some people say, well, you don't do that until close to trial. If you do that early on, it'll focus you on the issues and how you're going to present evidence as to each of those issues. All right, so no questions. Anybody can call me at any time if they have any, and I'm happy to answer them. We're a little less than an hour, but
also, please email me at jchilcote@lgclawoffice.com so that I can make sure that everybody gets their proper MCLE credit for this seminar. Again, that's jchilcote@lgclawoffice.com.
all righty. Well, thank you very much.